The Age Discrimination in Employment Act of 1967 applies to employers with 20 or more employees, and prohibits employers from discriminating against men and women over 40 years of age by employers, by government agencies, unions, and employment agencies. Now, I think it's important to note here that it is possible under the law for a 55-year-old to file the lawsuit because they might believe they have been omitted, let's say, in the promotion process, and the benefit of a 45-year-old. So here we've got both people over 40 years of age. Now, the same principle cannot be applied when it comes to employees under 40 years of age. So, for instance, if an employee who is 35 years old feels they've been unfairly treated at the cost of, let's say, promoting a 25-year-old, well, that principle does not apply. It does not apply in this case. Liability under the Act depends depends on the fact if whether the trade, in this case the age, motivated employer's decision. And I should say traditionally that was the case. It was the case up to 2005. In 2005, Supreme Court changed that principle, and the March 2005 and 5-3 decision, Supreme Court gave employees the right to sue the employer based on age discrimination, regardless of their intentions or motives. Now, employees, in other words, no longer needs a smoking gun to sue the employer. They only need to show that company's policy favors younger employees at the expense of older. Now, the Act allows for the doubling of damages. That means back wages, benefits, plus liquidated damages in cases of so-called willful violations. And again, Supreme Court became helpful here by clarifying the definition of willful violation as meaning that, quote, the employer either knew or showed reckless disregard for the matter of whether the conduct was prohibited by the Act. So in other words, willful violation has to be interpreted as something more than just being motivated by wrong intentions, but basically being mean to the affected employees. Now, here, of course, the decision of the Supreme Court is somewhat doubtful in terms of how helpful that might be for employees, and many believe it only cracked the door for the employees, because in reality, businesses always have that option, always have that defense in BFOQ, in bona fide occupational qualification, or business necessity. Now, let me give you an example of a BFOQ, business necessity. The case under which the issue came up, Jackson, Mississippi, the police department, in an effort to attract more police officers, decided to raise the salaries of junior officers, those under 5 years of service, disproportionately higher than those with more seniority, above 5 years of service, who filed the lawsuit under the Age Discrimination Act. And the court decided that in this case, the police department had a reasonable explanation for the decision, and they decided that staying competitive by being able to attract younger officers is actually a valid reason, is a business necessity. Another example of business necessity is the difference in Hodgson versus Greyhound Lines Incorporated. There, the company had a policy of limiting new driver applicants to persons under the age of 35. The U.S. Court of Appeals held that Greyhound did not violate the act because its hiring age limitation had a rational basis. Limiting the age actually enhanced not limiting the age of drivers would enhance the risk to the passengers. So of course here the assumption was that younger drivers can ensure a safer transportation of the passengers. Of course, those kind of cases require evidence and expert opinions.